Okay, now we are going to start our chapter number 2, Sources of Law. Which of the following is a statement by a judge that is the basis for their decision and what becomes binding on future judge? Okay, there are three terms. First one is obiter dicta, second one is per incurium, third one is ratio decidendi. Now, what is the difference between three terms? First one is obiter dicta. Obiter dicta means by the way or not a binding. It is the one which is not a binding. Not a binding. Second one is per incurium. It means a legal term made without care. So we can say no care. But our question says that by a judge that is basis for their decision and what becomes binding for the future judges. So ratio descendi is what it is binding for the future judges. So this is the right answer. Next one is which of the following types of court decision occurs when a court higher in the hierarchy overturns the verdict of a lower court? When a court is uh, overturning the verdict of the lower courts, it is called reversing. Answer of this question is reversing. But what does it mean overrule? Overrule means Supreme Court overturns the decision of a lower court in a different case. And distinguishing means it occurs when a judge decides not to follow a precedent in the case before them, or material facts of the two cases are completely different. This is called distinguishing. So when a court, higher court in the hierarchy overturns the verdict of a lower court, this is called reversal. Next one is which of the following statement in relation to legislation is correct? Legislation means your law. Legislation may modify or replace existing statutes. Legislation may not overrule or modify existing case laws. Legislation may prevent a subsequent parliament from changing the law. It is always possible to modify or replace existing statutes. In fact, parliamentary sovereignty uh, requires that it is always possible for the legislators to bring change or replace the existing laws. Next one is which of the following types affect specific individual or groups? Specific individual or groups. When we are talking about a specific individual or groups, it means we are talking about private. This is the one types of private legislation is the one which is relevant with specific group. Public is relevant with general public. And next one is enabling. What does it mean? Enabling legislation empowers a specific individual or a body. This is called enabling. So the correct answer is private. Okay, next one is which of the following rule of statutory requirement states that word in a statute should be given their plain ordinary meaning unless there would give rise to a manifest rusticity or inconsistency with the rest of the statute. So, in the question, he is saying which rule of the statutory interpretation states that word is a statute, words in a statute should be given their plain, ordinary meaning unless this would give rise to a manifest abruptity or inconsistency with the rest of the statute. This is called general rule. What is this general rule? General rule states that word in a statute should be given in their plain, ordinary meaning and give rise to manifest inconsistency with rest of the statute. But what does mischief? Mischief says that judges should consider what mischief the act was trying to prevent. And what does it mean? Contextual rule. Contextual rule says that a word should be construed in its context. So contextual rule means what? Word should be construed in its context. So here the right answer of this question is general rule. Next one is which of the following is an intrinsic aid to statutory interpretation? Intrinsic aid means already part of something. And Hansard, the long title of the act. And the third one is Law Commission report. Intrinsic aid to statutory interpretation is the long title of the act. Means what is the title of the act? Hansard and Law Commission report are not part of the act and therefore extrinsic aids. This is called what? Extrinsic. This is also extrinsic and this one is intrinsic. Which of the following is the final appeal court for human rights? Right issues for persons living in the UK. So those who are living in the UK, for them, final Supreme Court or the final appeal court for the human right is European Union Court of Right. Next one is which of the following court is binding on the Court of Appeal? So Court of Appeal, court is binding on the Court of Appeal. The Court of Appeal. This one is the binding. The only court that bind the Court of Appeal are the Supreme Court, the European Court of Justice, and itself. Next one is which of the following statement concerning the principle of binding precedent is not correct? Principle of binding precedent is not correct. Mistake by judges are eliminated. Mistake by judges can never be eliminated. The other options are the correct statement concerning binding precedent. We can follow general legal principle are established as a binding precedent. The law is based on actual rather than theoretical cases. The law is flexible and can develop with changing circumstances. Mistakes by the judges are never eliminated. Are eliminated. This is incorrect. Are can never be eliminated once judges has made any kind of mistakes. Next one is which two of the following are stages that a bill passes through before becoming legislation. Two of the following are stages that bill passes through before becoming legislation. So the first one is report stage and the second one is committee stage. The stages that bill passes through before becoming legislation are first reading, then second reading, then committee stage, then report stage, then third reading, then pass through the same stages in the other house and royal assent. So first stage, so these two are the relevant. Fourth reading and approval are not relevant or not considered. Next one is some statutory instruments require a resolution of parliament to become into effect, but other must be laid before parliament for a particular period of time before coming in effect. Some statutory instruments require a resolution. They require a resolution of parliament to come into effect, but others must be laid before parliament for a particular period of time before coming in effect. How many days must statutory instruments be laid before parliament before coming into effect? How many days? 40 days. Statutory instrument must be laid before parliament for 40 days before coming into effect. Next one is which rule or approach to statutory interpretation consider with legislation is trying to achieve. Which rule or approach to statutory interpretation consider what the legislation is trying to achieve, what the legislation is trying to achieve. Purposes approach, purposive approach. Under the purposive approach to statutory interpretation, the purpose or what the legislation is trying to achieve is considered. So this is the relevant answer. Rest of the three answers are not relevant. We have already discussed contextual rule, golden rule. Literal rule means what literally is doing or what actually is doing. Presumption of statutory interpretation provide judges with rules to use when interpreting legislation. Which of the following statement in relation to presumptions of statutory interpretation is correct? A statute may not deprive a person of their property. A statute does not have retrospective effect. There are two things. First one is called retrospective, or the other one is called prospective. Retrospective means past, and prospective means future. So none of the law can affect the past. Statutory does not have retrospective effect. Statute binds the crown, yes. The statute effect outside the UK, yes. And statute may not deprive, sorry, no. Bind the crown, no, it is not binding the crown. Similarly, it is not by a statute has no effect outside the UK, and statute may deprive a person of their property. So what is the answer? Correct one. Correct one is there is no retrospective effect of the law. Which of the following is an extrinsic aid to statutory interpretation? Answered. Extrinsic aid do not form part of the act. It is an example of, Hansard is an example of extrinsic aid. Last one is which two of the following statements in relation to the impact of UK human rights legislation are correct? First one is all new parliamentary legislation must be compatible with the European Convention on Human Rights. Number two, all courts may strike out secondary legislation that is incompatible with the European Convention on Human Rights. Number three, courts may interpret legislation in such a way that is compatible with the European Convention on Human Rights. Courts are not required to take the decision of the European Court of Justice when making their decision. So in this case, right answer is the court may strike out secondary legislation that is incompatible with the European Convention on Human Rights. And next one is court must interpret a legislation in such a way that is compatible with the European Convention on Human Rights. So these are the answers of chapter number 2.